A very warm welcome to everybody and to our panelists. Our panelists, of course, I will introduce them to you later. Before we get on to the process of talking about the event today, let me introduce to you the concept of the EduSikh. EduSikh is an initiative that is now almost a year old. We began last year with a big event where we promoted Punjabi as a language, our Marboli. And thereafter, we have ventured not only into the education, but also into various other sectors. Last month, we had a virtual event on the MSME, and various such initiatives have been undertaken. Today's event, of course, focuses on what happens if a will is not created or left behind. Keeping in mind what the Hinduja brothers are going through today with such discord and disharmony, I think the event and the session today will have great importance for businesses of all sorts, whether organized or in the unorganized sector. To start our series of talks, we will first invite our main partner, the Dadar Shri Guru Singh Sabha Gurudwara, and I would request Sardar Manmohan Singh Ratiji to please address the audience before we take the event forward to the next speaker. Sardar Manmohan Singh Ratiji.
वाहिगुरु जी का खालसा वाहिगुरु जी की फतेह. In the series of these digital meetings and conferences on Zoom, one step ahead, we are today focusing on succession plans and how to make a will and what are the frequently asked question and answers addressed in the meeting by our respected Sahni Saab and other speakers, Paramjeet Singh ji. I'm very much thankful to the organizers, which we are also a part of. But KP Singh ji, Paramjeet Singh ji, Sahni Saab, and I really appreciate that at least we have started something which is the need of the society other than religion, education, health, because we have seen so many of fights amongst the children of the same mother, father, blood relations, cousins also, and two generations down the line, the tree becomes very complicated. So it is very, very important in this today's times that we should have a proper succession plan and a proper will for which this meet has been organized. I won't take much of your time. I request KP Singh ji to please hand over the screen and mic to the next speaker. And Singh Sabha will always be with the community for the well-being of the community in any platform and any subject which is relevant to the current lives and the lives of the future generation. Thank you very much. Vaheguru Ji ka Khalsa.
Thank you, sir. Always an inspiring presence in our lives. Manmohan Singh Rathi Saab, thank you very much. Before I introduce the next speaker, let me talk to you about Sukhbir Singh Virji and the work that he has done. Over 30 years of experience, a chartered accountant who stood second in all India exams for a chartered accountancy. He is a highly motivational speaker and has addressed several seminars. He works as a virtual CFO for companies across the world. And I could not think of a better person to advise us what can be the implications if we do not have a succession plan in place. And therefore, for the next 15 minutes or thereabouts, we will love to hear from you, Sukhbir Singh Virji. And the format of our session today will be, both our speakers, our panelists, Sukhbir Singh Virji will talk first, and then Paramjeet Singh Virji will talk later. Thereafter, we'll open the debate up for a Q&A session. May I request that all of you use the chat session at the bottom to put in your questions, and all the questions will be answered at the end of the session. We will not be answering questions during the session as it progresses. It will disturb the flow of the whole show. And therefore, for the next 15 minutes, I would request Sardar succession plans.
Uh, Thank you, KP. I'll just share my screen. So, friends, today we are going to talk about succession planning through wills. There are other instruments of planning like a trust, but we are not going to talk about trust today. We are going to focus ourselves mainly on wills. Uh, my whole effort here would be to keep it as simple as it really is, because believe me, it is not at all very complicated. Somehow, people feel that, wills are very complicated. It is very simple. And at the end of the session, if you feel that, oh, this was so easy, so in reality, it is like that. So what is a will? Basically, a will is a legal declaration where a person says that after my death, this is how I want my assets to be distributed. Okay, so he makes it very clear that how he wants his property to be distributed, so that later on there is no what you can say fight or no kind of disputes amongst the various legal heirs. Uh, it is a unilateral document. It means that if I'm making the will, I don't need the consent of anybody else in respect of property which belongs to me. If the property does not belong to me, it is jointly owned, then there can be issues. But if the property belongs to me, I can decide unilaterally how I want to distribute that. Remember, a will takes effect only after the death of the person, and before his death, he can always revoke the will or he can make a fresh will. When he makes a fresh will, the old will becomes invalid. Okay. The wills which are made by Sikhs, basically, it is covered jointly in Hindu, Buddhist, Sikh, and Jain. They are covered by the Indian Succession Act. As far as other communities are concerned, for example, Muslims, they are covered by the Shariat. As far as Parsis and Christians are concerned, they have their own personal laws as well. So we are going to focus mainly on the Hindu, Buddhist, Sikh, and Jain in this particular session. So the question is, who can make a will? Any person who's of a sound mind, okay, he can make a will. A minor cannot make a will because he's not capable of contract. Now the question is that I made the will when I was of a sound mind, and later on, due to my ill health or any such issues, I am no longer of sound mind. In that case, the will which I had made when I was of a sound mind, it will prevail. It will still be valid. Physical handicap is not a bar, because a person may be paralyzed, but he is of a sound mind. He can still make a will and he can put his thumb impression there. The most important thing is that it should be done willingly. So if somebody puts a gun on my head and says, do you sign the will? And even if I have signed, later on if it is proved that there was a coercion, then that will not be valid. So what are the properties which can be willed out? Any property which you have acquired, which is in your name, can be willed out. Even ancestral property nowadays, earlier it used to be the HUF property, but now the law is very clear. Even the ancestral property which you have got, that also can be willed. Any movable property, maybe it is tangible or intangible. Let us say you have a website, okay? Now that's not a tangible property, but that website, or let us say a YouTube channel, it is generating a lot of income. That also you can transfer by a will. Tenancy rights, this is like the Pagdi property. Whether that can be willed, answer it is that it depends on the State Rent Control Act. In certain states it is allowed, in certain states it is not allowed. In Maharashtra, in Mumbai, it is not allowed. It will go as per the provisions of the Rent Control Act. Right in a partnership firm, you cannot tell your partners that after me you will have to take this person as a partner, because partnership is a contract between the partners. If there is no consent, there cannot be a contract. So a partner can refuse to take your legal heir as a partner. However, whatever is your capital is on that date, based on the accrued profits and the valuation of the property, that will belong to the legal heir. They cannot be deprived of that. However, you cannot stipulate that you must take the person as a partner. Okay. As far as the shares in company is concerned, yes, they can be transferred by way of a will. So how do you make a will? Simple rule is it should be in writing. Okay. An oral will is not a will. It has to be in writing, and it can be on a plain paper. It is not necessary that it should be on a stamp paper. A will always has to be signed, and if you cannot sign, then your thumb impression has to be there. And when you are signing or you're putting the thumb impression, the intention should be very clear that you are doing it knowing that this is a will. Okay. The will has to be attested by 2 witnesses. Minimum 2 witnesses have to be there. The witness need not know what is written inside the will. They are just saying that the person has signed it in my presence. They need not know what is written inside. However, the signature must be in the presence of the person who has made the will. These are the simple rules of executing a will. Question is, should a medical doctor be one of the witnesses? Well, if the person is old and there is a chance that, in future somebody might challenge the will, then it is better to have a doctor who certifies that the person is of a sound mind. Otherwise, in case of a healthy person, it is not necessary to have a doctor as a witness. Who can be a beneficiary? Any person who can hold property, he can be a beneficiary. He can be a non-relative. It can be an artificial person like a trust or a deity. He can be, even the trust can be a beneficiary. Important thing is that the person should be in existence at the time of the demise of that person. If he is not in existence, then the property cannot go to that person. Okay. Sometimes what happens that instead of naming a person, you are describing a person. Let us say you are saying that it will belong to my son, Mr. So-and-so, and his children equally. Now, when you made the will, you did not know how many children he would have. So later on, if he had 3 children, then it will go to the son and those 3 children. Okay. You can give the property to a charitable trust. You can give the property to a private family trust also. But I'm not covering the part of the trust today. Revocation or cancellation of a will. Suppose you have made the will today, and after 5 years, you have changed your mind. You can easily revoke the will. What happens is that you simply tear off the old will, or whenever you make the fresh will, automatically the previous will is invalid. So it is always the latest will which will prevail. Okay. And if suppose the will is lost, it will always be presumed that the will has been revoked. Every will has an executor. The reason for that is that suppose when the person dies, he cannot execute what has been mentioned in that document. So you need another person who would execute on your behalf when you are no longer there. Okay. So that person is called as an executor. So generally you will make somebody you trust as the executor. Sometimes, in case of large properties and all, people appoint even professionals, there are trustee companies, they are appointed as executors. But generally, it is some trusted family member, some friend who is made as the executor. The executor can also be a witness. It is not necessary. He may or may not be the witness. Executor may also be one of the beneficiaries. And many times, the testator, he specifies that the executor will get a fee. For example, if you are appointing your lawyer or if you are appointing your chartered accountant as your executor because you trust him, and because he is going to devote his time, you specify that he will be entitled to a particular fee for doing the whole assignment. Registration of the will. Well, there is a lot of misconceptions around this that, the will should always be registered. The answer is that it is not compulsory. You may or may not register the will. If you register the will, it becomes a public document. Another option is that you can keep the copy of the will in a sealed cover with the registrar. sometimes, I mean, we also advise that, instead of registration, you just go to a notary and you sign it in front of the notary and just follow the proper procedure of writing in his register, because I mean, just a chapa notary should be avoided because he would never know you. So it is always better that you go to the notary and sign in that particular register, or you call the notary home and you sign on that register so that, it is done properly. What is the format of a will? Well, there is no particular format. You can write in plain language. It could be English, it could be Punjabi, it could be Hindi, whatever is the language of your choice, you can write the will. Important things is that you should specify that these are my legal heirs, these are my assets, and this is what I'm giving to so and so. If you're not giving something to, say, one particular son or to a daughter, it is better that you give a reason why you have not given, because otherwise there is always a chance that it might be challenged later on. So this is, I mean, a basic things, I mean, the ingredients of a will, and always specify the executor very clearly. What are the precautions to be taken? Be very specific. I mean, write the name very clearly, the full name. I mean, similarly, the property, describe it. Just don't say my house at Khar. Okay, give the full address. So what happens is that there is a very, very clear mandate, so that there is no vague or anything which is left for dispute later on. You must also give a clause regarding residual assets. What happens is that today you have 10 things. Maybe after a year or maybe after 6 months, you may have a few other assets. So generally in the end, you always write that any other asset which has been missed out, that will belong to so-and-so and in what particular ratios. Because many times what happens is that let's say you have 2 or 3 children and you have not specified the percentage in which they are going to get it. But you had in mind that my son should get 40% and the daughter should get 30% and the youngest one should get only 10% or whatever. Those ratios are there in your mind. Please specify that very clearly. Otherwise, I mean, by law, it will go equally. Yeah. So it's always better that whatever is there in your mind, make those things very clear. Similarly, if there is any liability, let us say, I mean, for example, you have been admitted to a hospital and there is a bill. Okay, who will settle that bill? From which asset the bill would be settled? Make it very clear. Sometimes you also create a life interest. For example, for some reason, you want that after you want your house to go to a son. However, you want to take care of your wife also. So you are specifying in the will that my wife would have a life interest in the property. A life interest means that as long as she is living, you cannot sell the house without her consent. Okay, but she is not having any legal ownership. So that is the meaning of a life interest. Yeah. There is another clause called in terrorem clause. Now what happens is, let us say for some reason you want to give, say, only 20% of your property to one particular child, and remaining 80% you want to give 40-40 to 2 children. So total 3 children, 40-40-20. Now what can happen is that the guy who's getting 20, he will challenge the will. So many times in the will, you put a clause which is called as in terrorem clause, saying that if any of the beneficiary challenges the will, he will lose even that 20%, whatever you have given. So what happens is that you are, creating a deterrent that he will not create any nuisance later on. Because if he challenges the will, then and he loses, then whatever that 20 he was getting, that also will go. Okay. A codicil, I mean, it is like a will when you want to make a minor change. Let us say after 6 months you bought one more property, and that property you want to specify. You have 2 options. Either you you rewrite the whole will, or you say that I had made a will on so and so date. Thereafter, I've got this property, and for this property, this is how it will go. That is called as a codicil. So if it is a minor change, you make a codicil. But if you want to make any major changes in the percentages and all, it is always better that you make a fresh will and you cancel or you tear off the old will. Yeah. Multiple wills, it should always be avoided. I mean, the only case where I would recommend multiple wills in case of non-residents, where for their Indian assets, they make one separate will, and for other countries, they make a separate will. Otherwise, a single will is important. Where do you keep the will? Well, it is very important, because if you have kept it somewhere and nobody else knows it, I mean, what's the point of making the will? Because if nobody else knows it, how will it get executed? So people sometimes they keep one copy of the will with the executor, maybe with some trusted friend, maybe with the spouse. I mean, it is kept somewhere where it is likely to surface after you have gone. Okay, that is very important. Special consideration for non-resident, I'll cover this very quickly. What happens is that if you're a global citizen and you have certain assets in India, now if it is an immovable property, it will always be governed by the laws in India. However, if you have movable property, then it will be covered by the country where you are domiciled. Okay. Now, this concept of domicile is very interesting because it is different from citizenship and residency. Now, what is citizenship? Citizenship goes by your passport. If I'm holding an Indian passport, I'm an Indian citizen. Residency goes by how many days you have spent in a particular country. If I live in Dubai, I'm a resident of Dubai. Okay. But domicile is something where you intend to live. Now, what happens is today I'm working in Dubai and therefore I am a resident of Dubai. But I have kept a house in India and it is my desire that once I retire, I will go back to India. So always my desire is to go back to India. Okay. Or let us say I migrate to Canada. Okay. I get a Canadian PR or even I get a Canadian passport. So I'm a resident. I am a citizen of Canada. However, still my desire is that I want to go back to India, and therefore I have a house here in India which I am maintaining and I am coming regularly to India. So domicile is basically desire. Now this generally the country of your birth is called your domicile, which is the domicile of origin. However, you can express in your will that my domicile is India and therefore your movable assets will be governed by your domicile. Okay. You have to be careful if you are living in countries like say France, Saudi Arabia, Dubai and all. They have the concept of forced heirship. Now in a forced heirship, for example, in Dubai, you have something. So it will go by the Dubai laws, your immovable property. Okay. So there the concept of forced heirship would apply. In certain countries, you have the concept of a community property. So what happens is in certain countries, if you acquire any property after marriage, it will always be deemed to be owned jointly by the two spouses. Okay. So there is no concept of an individual property. It will always be treated as community property. Now, there are certain states, certain countries where this concept, especially in the US, there are a lot of countries, states where the concept of community property is there. In India, we do not have this concept of community property. So if you are a resident of US, then you should be aware of this as well. So depending upon your movable property and immovable property will always go by the laws of the country where it is located, but movable property will go by your domicile, and therefore in respect of your movable property, you will be able to do something. Yeah. Separate will is advisable for NRIs in respect of assets in India, because then what happens is that you don't have to wait for the overall will to get probated. Otherwise, what happens is that because your assets in US, they have not been properly resolved, even your transition of the Indian assets will get stuck up for that reason. And therefore, it is always better that for your Indian assets, you make a separate will. Okay. basically, if you're a non-resident, these are some of the tips. I mean, in respect of immovable property in India, you have the Indian will, then the domicile, registration. I mean, basically all the other conditions are the same, but you just need to be aware that whether it is immovable property or movable property, where is your domicile in the will clearly express that my domicile is India for so and so reason. So, you know, you won't have any problem in doing this. Yeah. Coming to the process of nomination and probate. I mean, what happens many times people feel that I have made a nomination, so I will not make a will. That is not the correct way of doing it. What is nomination? I mean, nomination is the act of informing the custodian or the authority. Let us say you have a house in a cooperative housing society. So you fill a nomination form and you tell the secretary that after me, I want the flat to go to be transferred to so and so. That is just a nomination. Legally, a nominee is not the owner of that asset. Nominee is just a caretaker. He's like a trustee of that asset, and he is still accountable to all the legal heirs. So this we have to be very clear that just by making a nomination, you feel that, oh, I have made a nomination for my wife, for my fixed deposit or for my bank savings account, and therefore automatically she will become the owner. This is a big misunderstanding, because later on the children can demand that we are also the heirs, and therefore the nomination, your desire, will not be fulfilled. So whenever you are making a nomination, always remember your will should always be made, and it should be in conjunction with the nomination. Don't have a situation where the nomination says one thing and the will says something else, because that leads to disputes. Always create a synchronized document where the nomination and the wills are synchronized. Okay. A very important thing, there was a Supreme Court decision which says that, you know, if a nomination has been made, the society should simply transfer the share certificate to the nominee. Well, the Maharashtra Cooperative Society Act has been amended after that decision, and it says that the nominee will be admitted as a provisional member. So he is not the final owner. The final owner will be as per the will or as per the law. So this becomes very important, especially for high value items like the house and all. Always file the nomination with the society and make sure that you write a will which is in tandem with that nomination. Nomination in respect of shares. Well, there was some decisions where it was held that the nominee becomes the final owner. However, Bombay High Court has overruled that decision, and they say that nominee is just a caretaker. And in my opinion, this is the correct interpretation. Nominee is not the owner. Nominee is just a caretaker or a trustee, and it will go to the legal heirs. And to avoid that, you make a will. Yeah. Joint holder, like even in case of a joint holder, what happens? Let us say I have made two accounts, two names in my account. First name is mine, second is my wife. If anything happens to me, automatically the bank will give the money to my wife. Okay. But is she the owner? Answer is no. She is just a caretaker. Automatically, she doesn't become the legal owner. It is always necessary that I write in my will what I want to happen. So whether a joint holder or a nomination, always make sure that the second, you supplement that by having the will. What is a probate? Well, a probate is a copy of the will. Let us say after the person is gone. How does a person know that this will is authentic? So you have to go to the court and you get a certificate from the court saying that this is the final will of the person. Question is the probate compulsory? The probate is compulsory only in 3 states, which is Maharashtra, West Bengal, and Tamil Nadu. These are the 3 states because the Britishers had made this rule, and somehow, I mean, the Indian lawmakers have not bothered, or this has escaped their attention. And therefore, I mean, if the immovable property happens to be in these three states, then the probate has to be obtained. It becomes compulsory. But let us say you are in Delhi and your immovable property is located in Delhi, you've got nothing in Mumbai. I mean, even without the probate, with the copy of the will, you'll be able to get the transmission done. Okay. Generally, the court fee is payable for the probate, and the maximum court fee is 75,000. What if there is no will? Well, this particular slide I am going to skip because Paramjeet Biji is going to take it. So the only question is whether a professional should be involved in preparing the will. See, if you are knowledgeable enough, you know the particular rules, you can make the will. It is absolutely simple. Just follow whatever precautions I have told you, exercise those. However, I mean, if you feel that, you know, it is better to involve some trusted professional, because many times what happens is that, you know, you have disclosed everything to your chartered accountant, or you can go and talk to a lawyer and he would help you in drafting a will. Because what happens is that your language might have some vagueness, and a professional always helps by questioning that, see, this is what you have written. This can also mean this. And therefore, you know, it always becomes better that there is one other person who has vetted your will, so that later on there should not be any problem. Yeah, because after you don't want your family to be fighting over what has been left behind. Yeah. So this is what I have to say. Thank you so much. If you have any queries, you can raise them now. You can even write to me personally at sukhbir@sukhbir.net. I will try my best to, you know, answer your queries. Over to you, KPVG. I'll stop sharing.
Thank you very much, Sukhbir ji. When you say I will try to answer, I know the kind of discipline you follow. I'm very confident you will answer. But it was a very insightful presentation. And there are things that I'm sure most of us didn't even know about, the nominee part of the bank accounts that we have, and we simply presume a lot of things. And I was so glad to hear you talk about the community aspects, because I know today Mrs. Jeff Bezos is the world's second richest woman because of the community aspect that you presented. Yes. Thank you so much. But bringing into perspective the sheer vagueness or lack of chaotic circumstances in Indian businesses, and I'm talking of the organized sector. I went to the MCA site, sir, and I found that there are 1.9 million companies registered, of which only 11 lakh are active, and even more shockingly, only 7 lakh are filing active returns. If this is the chaos in the registered sector, then the fear is in the unorganized sector, there is obviously bound to be even more chaos. And therefore, what you spoke about today has great pertinence. Now, it's with great privilege and happiness that I present our next speaker of the day, Sardar Paramjeet Singh Virji. He is an IRS, Indian Revenue Services officer. But to us, more importantly, he is a great visionary. He is a philanthropist. He is an author. And very importantly, a highly motivational speaker as well. He is a founder member of the Dharma Bharati Mission, and of course, the EduSikh, the great foundation of building relationships among Sikhs and ensuring everybody grows and prospers. So I would now like Sardar Paramjeet Singh Virji to present about what happens if you don't leave a will behind. Sir, over to you.
Thank you. I'll request Pavinder to share my screen actually. Pavinder ji. Pavinder, we'll have to go back to the first one. First slide, please.
While that is happening, a quick note, we'll address Q&A at the end of the session.
Okay, thank you very much. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. So I'll be talking about intestate succession, which is when you don't leave a will. and of course discuss some practical issues, even if there are wills, and how to do that. So yes. So basically, what we are talking about when we are talking about succession planning. Succession planning is all about fair distribution of assets. And this has been happening in India for many years. And but it has been codified in the Indian Hindu Succession Act and the Indian Succession Act. Basically, in when we are making will, will banande, we have to take into account the financial needs of the family members as well as the equitable distribution of wealth. क्योंकि विल बनाना खाली ये नहीं है कि मेरे असेट्स किधर को जान गए विल नहीं बनाया तो मतलब जिस तरह अगर तुम देखोगे इट इक्वली गोज टू ऑल द फैमिली मेंबर्स but because we are making will, because we want to be, there should be an equitable distribution of estate among the heirs. That is why it is not just about writing a will, but how do we plan our affairs while we are living. We use a combination of these three things: will, trust, or gift, either individually or a combination of these three things to manage our affairs when we are alive. And today, as Sukhbir ji mentioned, we'll be talking mostly about will and gifts, but not the trust, because that is a separate subject altogether. In India, there is no actually state law which governs about wills, succession planning. It is the religious laws that prevail. So Hindus are governed by Hindu Succession Act, Muslims are covered by Shariat, and Parsis and Christians, they have their own Succession Act. So if there is no will, if you have not made any will, then your assets will be equally distributed to all legal heirs. Now, what are legal heirs? We will see what are legal heirs. And acquired wealth can be willed at choice to anybody or even donated. What I have earned in my life and what is acquired wealth, I can will it to anybody. I can give it to not only my family, strangers, or even donate the entire thing to charity. But the ancestral wealth cannot be willed at sweet will. Sukhbir ji mentioned that it can be willed. It is only my portion of the ancestral wealth that I can will, because the ancestral will is a joint property of myself and my children. It cannot be willed to anybody. It has to go equally to all the legal heirs. I'll discuss this more in future. So what happens when there's no will? First of all, that most of us don't make a will thinking that, we are not that old and we're not going to die. There's a stigma attached. If we sell somebody, you make a will, say, oh, I'm not that old. I don't need to make a will as of now. But the prudence says now that as soon as we hit 50s, we should make the will, especially, or even earlier if we have multiple assets and properties, or if we are anticipating some trouble over inheritance, some family affairs as such, so we should make a will. So that will. And without a will, as I mentioned, we are governed by this Amendment Act. And secondly, why we should, when we don't make a will, it is very expensive and more time consuming for our legal heirs to get the assets. If there is no will, they will have to run around spending large sums of money to get documents like succession certificates and letter of administration. These two things are required if there is no will to get the properties transferred. So the succession certificate is required in the case of movable properties, and the letter of administration is required for immovable properties. And of course, for getting both these, we'll have to appoint lawyers, which cost a lot. So first of all, it is very time consuming and very higher expenses are there, and that the legal heirs will have to run around. And secondly, if we are not making a will, there will be an undesirable distribution of assets. See, in my lifetime, I have earned so much thinking that, I want to take care of my family, my children. This child needs more, that child doesn't need more. But if I'm not making a will, then it is going equally to everybody. So it is an undesirable distribution. Say, like one example, say I have a minor daughter and who needs 1 crore for higher studies. If I don't leave a will, then that amount of 1 crore will be divided among the 5 legal heirs, and she will get just only 20 lakhs. So I earned it, I saved it, I wanted it to go there. Because I did not make a will, it has to be divided amongst all the legal heirs, and it cannot just go to her. Like in some other cases, it can happen that one son is doing financially better and others are not doing better. But because I have not willed, even the son who's doing very good, he'll also get the equal amount, and the son who's not doing very good, he will also get the equal amount. There can be a case where, say, one son is living and supporting mother and grandparents. Say, I leave only one house, and one son is living with the mother and grandmother there. And the other son is doing very well. He's living in some other town, or in the same town, he's living in his own house. But on the death, he can come back and claim that I want my share in this house because there is no will. And he is equal participant, equal responsible to get that, the house. What will the son have to do? Son will have to sell the house to give his brother's share. And he'll have to shift to some other house, though the mother and the grandparent are staying. This is because we did not make the will saying that get the house. Similarly, we can have a case, say we have a daughter who is not married, who decided not to get married, or is a widow, or is divorced, and is saying living with the family or the mother, and she may be working, she may not be working. I, in my lifetime, wanted that she should get this house and she should remain here and there should be no problem. But because I did not leave a will, the siblings can come back and say, no, we want our share of this house. And they cannot do. Legally, they are absolutely legally correct in asking their share in that house. So it is an undesirable distribution because we did not make a will. Then there may be cases of special need children, special need grandchildren, who may require more funds to be left for them. But क्योंकि ऐसी plan नहीं किया, we did not leave for them, and then everybody else will say कि हमें नहीं पता what will happen to them. We want our share and we want to go out. So what is the heirs? Who are the legal heirs? So basically, there are the law says the assets will first go, if you have not made a will, the assets will go to class 1 heirs. And if there are no class 1 heir, then it will go to class 2 heirs. So who is the class 1 heir? Who are the people who fall under the class 1 heirs? There are 4 people who form class 1 heir: son, daughter, widow, and mother. अगर एक बच्चा, एक कुड़ी, एक बच्चा है, like one son, one daughter, widow and father, so the property will be divided amongst these 4 equally. 4 हिस्से होंगे, चारों में बराबर बराबर मिलेगा. और अगर 2 लड़के हैं, मतलब बच्चे ज्यादा है, sons है, daughters भी है, 4 है, तो it will be divided into भी होंगे. So you see in this, father is not considered as a class 1 heir. Father does not get anything in the class 1 heir. Only these 4 will get the properties. What happens if this son has already died and his widow and children are there? So there can be a case where the son is not arrived, a son may have died before the father, and his children or his widow are also there. So then uda hissa, it will be divided among these 3 people. So 4 family member hai, one son, one daughter, one widow and one mother. 4 people are there. The son का जो 1/4 हिस्सा है और इन तीनों से डिवाइड हो जाएगा. They will get 1/3 or 1/4 each. Similarly, same हो सकता है कि daughter की death हो जाए तो daughter दे भी बच्चे हो तो उधे son and daughter उधर हिस्सा उन्होंने मिल जाएगा बच्चों को. They will get the, and it can keep on moving, like there can be a grandson, son of a predeceased son of a parent. So basically in हिस्सा 4 ही होएगा. उन्होंने हिस्सा उन्होंने बच्चों में जगह डिस्ट्रीब्यूट होता जाएगा जिन्हें बच्चे उनके. So this is the class 1 heir. If we are not having a will, the property will be divided among these 4 categories of people and their respective. Now son and daughter here include adoptive son and adoptive daughters also. If we have adopted son, he has equal right as a natural born son, uterine son. Similarly, daughter also, adopted daughter will get the same rights. Now, what are class 2 heirs? If suppose none of these are alive, then we have to move to class 2 heirs, which means then the father comes. If all those category people are not there, then the property will go to father. here in this class 2 years, it is not equally divided. If father is not there, then we have to move to the next person, the brother and sister, or son se daughter de bache. Is tarah matlab puri list hai. So it follows one by one. If father is there, then he will get everything. And then if father is not there, then the next category, then the next category. So all those relatives will come later. Father's father, father's mother, father's widow, all those things. So you see, if you do not have a will, the things become so complicated. And even if in the first case, in the class 1 heirs also, if there's say only one son, one daughter, and father, widow and mother, and if there's only one house property, everybody will fight that, no, I want this house, or I don't want this house, or I want to sell this house. I want money. I don't want the house. I don't want to wait till my mother dies. So all those things are there. Now, this is the division when similar is the case for a Hindu female. What I told was about the Hindu male, and Hindu male here includes the Sikhs, Jains and Buddhists also. Now, what happened when the property belongs to a Hindu female and she dies without a will? So how will her property be divided? So first it will go to the sons and daughters and the husband, and then to the heirs of husband, then to mother and father, and then to the heirs of father, and fifth to the heirs of mother. So all this is codified in the Indian Succession Act, where it says when there's no will, then it has to be divided like this. First, equally among those class 1 heirs. If class 1 heirs are not there, then class 2 heirs, and then in the case of female, it will come like this. Now, some people think that rather than making will, we can give the assets during lifetime. Even if you leave a will, there will be disputes. People will say, no, I want this house to be sold, I don't want this house to be there. So they think that gifting is a better thing. So gifting is actually not a better thing, as I will prove it in the subsequent slide. It is a double-edged sword. It may solve some problem. Gift nobody can challenge it. But if you gift a property in your lifetime, if as a parent, if you're gifting it, then you become vulnerable. ਤੁਸੀਂ ਆਪਣਾ ਗਿਫਟ ਪੂਰਾ ਹਾਊਸ ਆਪਣੇ ਬੱਚੇ ਦੇ ਨਾਂ ਕਰਤਾ, ਮੁੰਡੇ ਦੇ ਨਾਂ, ਕਿ ਸੋਚਿਆ ਕਿ ਬਾਅਦ ਵਿੱਚ ਕੋਈ ਕਲੇਮ ਨਹੀਂ ਹੋਏਗਾ, ਬਟ ਦੈਨ ਹੀ ਔਰ ਹਿਸ ਫੈਮਿਲੀ ਮੇ ਨਾਟ ਟ੍ਰੀਟ ਯੂ ਵੈਲ, ਪੇਰੈਂਟਸ ਡਿਪੈਂਡੈਂਟ ਹੋ ਜਾਣਗੇ ਉਹਦੇ ਉੱਤੇ. ਸੋ ਇਟ ਇਜ਼ ਨਾਟ ਅ ਵੈਰੀ ਗੁੱਡ ਆਈਡੀਆ. ਐਂਡ there are some assets which you can give, like artifacts, artwork, jewelry, but mostly it is very important to understand what is the difference between a gift and a will. The most important thing is that will, whether registered or not registered, it is revocable. He can change as many times. So they say will you can write as many times in your life, and the last will is considered the final will. But gift deed ek baar bana deti gayi, then it cannot be changed. Gift is something given, it cannot be taken back. It is irrevocable. So if you have made a will and circumstances भी कभी change हो जाते हैं, कि like you had planned that half my wealth will go to son and half my gold will go to my daughter, but suddenly क्या होया कि कुछ tragedy हो गई, कि son दे business पूरा खत्म हो गया, या the family में कुछ हो गया, some tragedy has happened in the family, and now you need to put more assets for your son or daughter, whatever be the case. So you can change the will and you can provide more for your son or more for your daughter. But तुझे अगर already will कर देता, then you cannot change it, and even if you want, you cannot do anything in that case. So example, तुझे देखा paper इस पढ़ा होगा, विजयपत सिंघानिया था. He in his foolishness, he gifted the entire shares of 1,000 crore to his son Gautam Singhania, and now he's 70-year-old and is suffering financially. If he would have willed it, he would have said, after my death, my son will get, he would have controlled, and he would have been respected. Now his son doesn't treat him well, and he's living like a pauper in his own house. And despite having 1,000 crores of shares, he's now suffering financially. So this is what happens when we gift the things. And secondly, there is a tax implication of gift also. If we are gifting some things to close relatives, then it is not taxed. But if we are gifting something to relatives who are not category, income tax is defined as specified relatives. Specified relatives, if you are gifting, then there's a tax also on the gift. So we have to consider all these things when we are trying to gift. Now, right of daughter in ancestral property. Till 2005, daughters did not used to have a right in the ancestral property. Only the current property which the father had, he could give or not give the share to daughter. But in the ancestral property, only the father and the sons used to have the shares. That was called the HUF, which was called. But now in the ancestral property, a daughter by virtue of her birth gets a share in that in the property. So father the self-acquired property, he can distribute by will. But the ancestral property, an ancestral property is something, as I mentioned, it has to be 4 generation old. Ancestral property definition देती हुई Succession Act which 4 generation तो जो property आ रही है 4 generation old, that is defined. It has not been partitioned. Then that is called an ancestral property. And that ancestral property, father is only a custodian. He also has as many children. अगर 3 बच्चे गए, so he is only 1/4 partner of that house. 3 बच्चे the automatic right है उस property which even law says that he cannot sell the ancestral property without the consent of his children, and he cannot will it to anybody. It will go to the children only. So if a father passes away without a will, the daughter will have the same rights as the son in the ancestral property as well as the self-acquired property. Self-acquired which equal share होगा, immediately उधर भी ancestral property will be daughter the same होगा. And the marital status of daughter has no, it is immaterial, even if she, sorry, I'll just go back, yeah. The marital status is immaterial. Even a married daughter has the same right as an unmarried daughter. But only thing is that this law, when it was made prospective. It was not retrospective because they partition ho chuke se, they did not want to touch. So if the father had died before 2005, then the daughter will not get anything in that property. It has to be from that day onwards only. Whatever has happened, partition agar nahi hoya property, then she will get the portion of that property. Similarly, HUF jade bhi Hindu and United HUF sunde daughter is now a co-parceler from her birth. And pehle se ki HUF ka karta only a male could have been a karta. Now a female can also be a karta of the HUF. And from 9th September, as I mentioned, the daughters are considered co-parceler and they have equal share. Now, only condition in their case is that the daughter should have been alive on the date or in 2005. If she has already died before 2005, then her children cannot claim a share in the property saying that my mother ka share you can give me now. So same thing, the father should be alive in 2005 and the daughter should also be alive in 2005. Then only this new principles will work. Now some practical issues. This was what I mentioned about what happens when we don't have a will. Now I'll mention some practical issues and suggestions which come even in case when we are making will and how to tackle these things. Like will, as Sukhbir ji has mentioned that will should be in writing. Well, the law provides that it can be declared orally also before witness. But of course, it is always better to have a written will because we have to ultimately prove the will. And even people will say कि will बना लेता ताँ भी लोग litigation कर देते. People will litigate, but having a will is much better than not having a will. And similarly, having a registered will is always better than having a non-registered will. So as you make things better, the problems for your legal heirs will get decreased. And if you are having minor children, say if I am making a will and I have minor children, and if I die before they attain majority, so even if I make a will, then also the court will get involved if I have not appointed a guardian. So if I have minor children while I'm making a will, I should appoint a guardian to look after those minor children. And that guardian will hold the property for the minor children till they get adult. And once they get adult, they will get the property in their hand. So it is very necessary when we are making will. And if we have minor children, we should appoint a guardian also. Otherwise, again, running around to the courts will happen. Now, proving the will, general allegation is that will is not genuine. And there are other wills and all those things, those issues come. So some practical suggestions from experience, we are saying that if there is a will, say, of 18 pages, 15 pages, so you sign each and every page of the will. And witness should also sign all the pages, because see, one can forge one signature, two signature, but on 18 pages or 15 pages, he'll not be able to forge signature of self and witness both. So second is, some people go to extreme where the assets are very high value assets and something. So when they make a will, they record, videograph the whole things. These are all very practical things that people do. And in Bombay High Court, there was a case where there was a allegation about will was fabrication, because the testator and the witness had signed each and every page. That itself was quite convincing for the court to say that the will was proper. Now, executor, he has already mentioned, but who can be an executor? Generally, it is better always to have a family member as an executor, so that if the family relations are good, of course, and the testator is confident. But if not, then the criteria is that whom the heirs respect, who can have heirs' best interest at his heart, who's capable, who's impartial. And if none of these are available, then of course we can appoint an outside professional. And second thing is most important, that he should be fairly younger than the testator. There's no point appointing a senior person who may die before the will is coming. Like some अपने age का friend बनाने का कोई फायदा नहीं है, कोई young person होना चाहिए who will outlive us and who will help the execution of the will. Similarly, witness the भी यही है कि generally it is ideally better to have a doctor, lawyer, or a chartered accountant as a witness to the will, because if the doctor is there, he can always certify if there is a dispute that the health was all right and he has signed the will in a stable mental condition. Similarly, lawyer or chartered accountant can always say that they had discussed the will with proper understanding and no undue pressure was there when he was making the will. And again, witness, who's beneficiary, he should not be a witness. One who's getting the shares in that will, he should not be a witness. And again, witness who understands importance, and he should be younger. Again, like executor, witness also should be younger, so that he can go to the court and he is alive when this execution happens. If he is called before the court, he should be there. Similarly, what is important while doing the will is that we have to make provisions that assure the dignity of the people. Like you want to give the house to the son, but at the same time, the parents and the wife are there who have no wealth or no income of their own, and they should not become dependent upon the sons. So one of the things that we can do is a house can be bequeathed to parents and wife, or like Sukhbir said, there can be life interest, and there should be some exclusive amount of investment made in their name so that they get a reasonable monthly income independent of the sons. They should not be dependent upon the son. So that is what, that is why will is very important to be made so that dignity is maintained. Business, of course, we can give to sons, they can carry on the business, but assets and investments should be somehow made that the wife or the parents, they should get independent income irrespective of the. And so all these suggestions are based on normal Indian family. Every family will have different circumstances, and the person who's drafting the will know the condition and he can judge and he can accordingly decide. Now, one question is whether we should inform the heirs. There's no requirement, but if there are healthy relations in the family, it is always better to inform the heirs about the inheritance. This gives a clarity to the family members and they know which business is going to come and they accordingly work in their lifetime. Then secondly, once a will has made, it should be reviewed periodically. Whenever a family member dies or some new family member comes in, like the will can be reviewed. In any case, a will should be reviewed every 5 years. And considering the financial position and circumstances, and we should discuss with a consultant, and if there is a need to be changed, we should change it. Now, business, how do we give will the business? So if there are more children and if there are more than one business, it is always better to give each branch separately to the children. This is the suggestion, and it can be segregated per branch. And sometimes it happens that one business is more profitable than the other. How do we compensate the other child? So one of the suggestions that is given is that the flagship company can have disproportionate voting shares, that somebody can hold more shares and run the business without any interference, but the profit have to be distributed between all the family members equally. So that so there are numerous ways which can be done, and it should be kept in mind by doing this. Similarly, in partnerships, generally people have partnership of two partners. Under the Partnership Act, if one partner dies, the partnership is automatically dissolved. So, and as a consequence of that, under the Income Tax Act, if the partnership is dissolved, it is considered as a transfer, and there is capital gains, which is quite heavy on the assets. So it is always better to have firms with 3 or more partners. But in some cases, 3 partners are not possible. So what we can do in those cases, we can form a company, private limited company, which can be the third partner. So this prevents the dissolution of the partnership firm when one partner dies. And it prevents and partnership deed should have clearly, Sukhbir mentioned that you cannot will the succession in the partnership, but what you can do is, if partnership deed can provide all those things, like who will be on the death of the partner, how his shares will be computed, which heir will get what, it can be written in that, and whether a family member will be admitted to the firm or not, that we can provide in the partnership. So partnership deed, while we are making, we should be very careful in making and provide all these things, especially if we have 2 partners. So today LLP is a much better vehicle to do business, because it has a permanent existence and does not get dissolved on the death of the partner. So we can explore but in case of LLP also, we can provide very clearly which partner will get what, on his children will get what, and whether the one of the members will get admitted as a partner, or his wife will get admitted as a partner. So we talked about joint holding of asset. It is very important to have everything joint hold in bank accounts, bank FD, shares, securities, everything should be jointly held. Similarly, in the nomination, he has already mentioned that I will not go over this. Nomination does not decide inheritance. The inheritance will always be divided what is written in the will, and what is, if there's no will, then it has to go equally. Even if my name is there in a property, if I get it will not mean anything, because वो 4 बच्चे नु जाना है तो चारों नु जाएगा equally. Nomination doesn't mean anything at all. So the golden rule, as he also mentioned, that the will, joint holding, and nomination, all this should be reconciled. So while I am making nomination, I should always, and while I am making a property in joint name, I should always remember मैं किस property नु किसनु देन जा रहा हूँ. उसी हिसाब नाल उसी वेले ही nomination भी उदा ही करिए खाली. If I am thinking that this house will go to my daughter, I should make her the nominee. And this bank account is going to my wife, I should make her the nominee there. Or accordingly, it has to be worked in tandem. Because otherwise, nomination, you are losing the advantage which we get as a nominee. Sorry, 1 minute. So the nominee, actually, nomination the faida ki hunda hai ki, like if the bank, if you are a nominee, it is not, the bank does not wait for the succession certificate or anything. It can still allow you to operate the account immediately. You get access to that. And even without probate nomination, you get the property registered and all those things. So when you have done nomination and you're easing the things, it should be in sync with the will. So everything has to be in sync. Now I'll just discuss 2 short cases which will tell you what happens when we don't have a will. So this is one question which says, my father died without a will. While alive, he had transferred properties to my mother and money to children, but without any registered gift deed. My mother is now refusing to give any property to me. Do I have any legal claim over it? See, once the father has gifted the property to mother, you cannot do anything, because it is his self-acquired property and he has gifted, and she has full right over it. But the immovable property, if you're gifting, it has to be registered. In this case, he's saying that it was not registered, so that gift deed is not valid. That property, immovable property, if you are gifting, it has to be registered. If it is not registered, then it is not valid. Father has died without a will. All the heirs will have equal rights in that property. So the mother cannot prevent the children from having, all class 1 heirs will have equal right in that property. Just because the father did not do that registration of the gift deed, so it will not have any value. Similarly, in a second case, when our father died without a will, I and my brother submitted a no objection certificate to transfer the house to our mother. Now she wants to sell it. Do we have any right to stop her from doing that? See, in the case of legal heirs, class 1 heirs, equal right, but any of them can file a no objection saying, I don't want any share and my share can go to anybody. And this is what these people have done. This brother and the person, he submitted a no objection certificate to transfer to house to mother. Now mother is trying to sell, whether he can stop them. So the question is, it will depend upon what kind of NOC that they have given. When the father had died without a will, actually the property would have come to all the legal heirs, class 1 heirs. But when they gave the NOC, they gave up their right. So it will depend on the provisions of the NOC. If in the NOC they have just written that we have no objection to our mother living till she is alive, then of course she cannot do anything else. But if they have written in the NOC that she can do anything with the property, then they cannot stop her from selling. So it is fully transferred and she has every right to do that. So then they cannot do anything. Now, some more clarification. Some people, like to make a will like this, saying that after my death, all my assets will go to my wife, and after that, it will go to my children. So this is not a valid will. You cannot decide what she will do with her property. Once you will everything to your wife, then it is her assets, and it is her right to gift it or give to anybody after she, when she makes the will. We cannot dictate that what she will do with her property after that. Once I have willed her, then it is her property and she can do anything. And if she may give to her children or she may give to her brother, sister, whatever, we cannot stop that. And if we wanted to do that, then we had to gift it equally to everybody that time only. And or we could have made a trust saying that equal share should have been there for everybody. Similarly, I was already mentioned that like nomination, joint ownership does not mean anything. If my wife are joint owner in a property, after my death, it will not go to my wife. It will go as per will, or it will be shared equally if I have no will. And in the case of NRIs, he has already, Sukhbir ji has mentioned, always better to have two wills, one for the assets in India and one for asset abroad. It happens that when you're getting it probated in India, something may happen, the will may get stuck. So even your foreign assets will get stuck, frozen if you don't have other will. So at least you have the other will, you can at least enjoy the foreign assets, so there's no problem there. Similarly, wife and husband should not do joint wills. Again, because when say both of them die and one of them will get stuck in the court, and so all the assets will get stuck. So it's always better to have separate wills. That's all. Any queries, as Sukhbir ji mentioned, we can always talk about you can write at edusikh@gmail.com. We'll answer the question, whatever are there as of now. Remaining questions, you can always write to us at edusikh@gmail.com. Thank you. Vaheguru ji ka Khalsa, Vaheguru ji ki Fateh. Back to you, KP.
Sir, thank you very much. That was extremely informative. And what really stood out was the issues of gifting. So what could easily be discerned from your talk was gifting is not the ideal thing to do. One should go ahead and make a will. So Paramjeet Virji, putting up a question which is in my mind is one of the issues with not having a will is, of course, running around, hiring lawyers, spending time in government offices. So a will obviously is the only way out. Otherwise, chakkar pe chakkar hoga, and there's bound to be a lot of problem. Right. In fact, a lot of people say the only person who's joyous is the person who's dead. But everybody who's left behind has got a lot of woes already. Let us not add more woes to it. So thank you for that very insightful talk. So Sukhbir Virji, while we wait for some questions to come in, you spoke about probate. So obviously, since Maharashtra is one of the 3 states you spoke about where a probate is necessary, so are you therefore suggesting that one drafts a will and thereafter it has to be probated? Is it compulsory?
Yeah. So if you have any immovable property here, you have no choice. It will have to be probated. There's no choice there. But what happens is that in the meanwhile, if you had made the nomination, then without the probate also, the society will transfer that share certificate or the bank will give it to you. Okay, so nomination becomes very important. So you should have the will also and the nomination also.
Right. And therefore, what Paramjeet Veerji said is, be smart, be clear what you want to nominate to whom, keeping in mind to whom you wish to will it to later on.
Exactly. It should be in sync,
It
because
has to be sync, yes.
most of the problems arise because they are not in sync. Nomination form says give it to A, will says give it to B and C. Now, obviously, there will be a fight. Okay, but if you had said the same thing in the nomination and in the will, where is the question of a dispute?
No dispute, actually. KP, there are 3 questions privately have come to me. I think I'll just read out and then maybe Sukhbir also can. So one is by Paramjeet Singh. He said, who all are classified as legal heirs as per law? I think we have answered that. The legal heirs as class 1, class 2, we have already identified. Legal heirs are son, daughter, widow, and mother. That's the class 1 heir. And rest of them are the class 2 heirs. So the second question is very long. Sukhbirji, please listen. It's a long question. It says, sister is staying in the ancestral house. Father, mother, both are expired. There are 3 sisters and 2 sons. Will was made, but known only to sister staying there. How will that be distributed? Will it be distributed only if it is sold? And is there any other way too? All the sisters are elder. One brother is not married. Younger one married, having 2 children.
Okay, quite a complex thing.
Yeah.
First of all, I mean, there is a distinction between ancestral property and inherited property. Okay, so earlier what used to happen was that whatever you are inheriting, that used to become a HUF property. However, later on, the law was amended, and as the things stand today, inherited property is not necessarily ancestral property. So one needs to have a clarity that what was inherited, was it an inherited property or an ancestral property? Ancestral property means a HUF property. Okay, so that has to be very clearly understood, because that's really the crux of the matter where the disputes start, and the courts have various kinds of case laws on that. Now the question is that the will is only known to the daughter who was staying there. That by itself does not make the will invalid. If there are witnesses, and these are reliable witnesses who are testifying that the will was made when the person was in a sound mind, there was no undue influence, there was no coercion, then that will would be valid. Now, obviously, if the person is old and staying with that one person, it becomes a suspicion that the person who was staying has used coercion or undue influence to, make the will in his or her own favor. So yes, I mean, these conditions are quite suspicious. Now, as long as the will is valid, everything will go as per the will. If you don't want, or you want to challenge the will, then obviously first you challenge the will will be set aside. If the will is set aside, only then it will go as per the Indian Succession Act, where class 1 heirs would come into play.
Okay. Second question is that, can you please explain, in case of joint property of a mother and son, in case of mother's death, how will the property be distributed? There's no will. So I think I have already mentioned, in case of a Hindu female, when she dies intestate, it is given in the slide that it will go as per the order that it is given. So in any case, joint property of mother and son, the son will not automatically have the property, even if it is joint property. As I said, joint doesn't mean anything at all. If there is no will, it is the Succession Act how it specifies the class with the order of the sequence of the. So son will, in any case, son is a class 1 heir, the first person in the category. So son, daughter, and husband will get the property, equal right in that property. And now there's one question says, can I will the proceeds of my insurance policy? I think that can be done, of course. You can mention yes.
Yes.
You can say that after the insurance money comes to house, it can be given to this person. You can absolutely will it It can go to anybody. You can will it to charity, you can give to family members, or it can go to anybody. There's no restriction on that. Then it says separate wills for joint property and joint accounts too. I don't know what that question means actually.
So there is a question also from Mahip Singh ji, who says, is there a time period for a daughter to put a claim in the property post the father's death?
No.
Is there a time period?
In case of property cases, especially in the will cases, there is no time. Yes, Sukhbir ji?
I mean, the only thing would be whether it becomes time barred. Now, what happens is that, there is something which is explicit, and there is another thing which is an implied conduct. Okay. Let us say today you have full knowledge that this is happening, and you do not raise any objection to that. So it is implied that you have given your consent to that. Now, after 10 years, you suddenly wake up, the courts are not going to entertain, because they say, I mean, there has to be some reasonableness. If you had any dispute regarding the validity of the will, you should have raised it at that point of time, not after 10 years.
No, but he was not aware of the...
If you're not aware, it's a different thing. If you're not aware, then it's a different thing. But it's very difficult to say that, hey, you are not even aware of your father's death. Which means you are not in touch, and therefore disputes can go on. But if you are aware of it, then you cannot wake up after 10 years, because implicitly you have given your consent.
Correct. Right. So there's another question from one of our attendees. If a husband has made a nomination in favor of his wife of the house property, and if something happens to the husband, wants to know what's the process to get the title in the wife's name. What's the process?
Okay. As I said, in Maharashtra, she will be admitted as a provisional member of the society.
Right.
However, as per law, the class 1 heirs, which means her mother-in-law is also a heir. Okay. So if she wants to become the legal owner, she will have to get a NOC from the mother-in-law. As far as the minor children are concerned, their share will always remain, because they are minors and they cannot sign a NOC. So legally, if let us assume the mother-in-law gives the consent, then the wife and the children will be equal owners, because minors cannot give you a NOC.
Right.
So it is better that the husband should always write the will in addition to the nomination.
Correct. And Paramjeet, this goes back to our executor part. So what happens if, I know you said that the executor should be somebody who's younger, don't go for somebody of your same age or older. But the question is by Gurmeet Singh ji, what happens if the executor dies? Obviously, in that case, if the will is valid, then you bring in another executor, I would assume. But what are your words on that?
So, Gurji, what do you say about the executor?
So, if I am aware, I should either make a codicil and say that instead of so-and-so person, I am appointing this person as the executor, or I write a fresh will saying that instead of this person is the executor.
No, but if I'm not
aware, suppose I am not aware and I don't do it.
Yeah.
I mean, your basic directions, your legal declaration that this is how I want to distribute, that still remains. Now the question is, who would do that? Now what happens in this case? A receiver would step in instead of the executor, and he will give effect to that.
Court will do that actually.
Right. So it's a longer question now. So he says, my Dadaji has already given money to my two buas for their house. And we did their children's marriages by contributing good amount of money and other gifts. He says, now me and my father, my Dadaji wants to give property to my and my father. if we do registered will of all assets, I hope my buas can't challenge them or ask for anything else. That is the factory, the house, the bank account, the FDs, and other such assets. So I think the question is, we have done so much for the buas.
Yeah.
Do they now have some claim?
No, see, the grandfather has every right to gift to a will to anybody. It's not necessary. He may not give 1 rupee to the buas. So if it is his self-acquired property.
But I would say, advise that he should mention in the will why he is not giving. He should mention that clearly. Okay, that is one thing. And if possible, make the buas as witness, so that later on they don't challenge that the will was forged or anything.
But he has every right to.
He has full right.
Even if he doesn't write anything, the will is valid, and
it is always better.
It is better. It will
because otherwise, it can be challenged. That see, they had used undue influence and all that.
But just to throw a curveball into this conversation, what if it was ancestral property, like 4 generations old? In that case, the buas have equal right.
Yes, they will have.
They have equal right.
They will have equal right, regardless of what happened or not.
The grandfather cannot deprive them of that property.
If it is a HUF property, then it is their right.
Correct.
The only way they can give up their right is that they can actually, during the lifetime, you make some kind of a family arrangement, and in that all these things are properly documented. There is something called as a family arrangement. What happens is that till the time the father is alive, maybe there is some moral pressure on the daughters to say that. Okay.
Right.
It might be better then in that case that you make a family arrangement and you say that this is what we have received, and therefore we have no further claims and we are renouncing anything that. So this is, another way of avoiding future disputes.
Avoiding future issues. Now, there's a slightly complicated question coming up, and it's very personal in nature. So the person writes, I will not identify him. I'm having 2 minor children. My wife has eloped 5 years ago, and he's tried hard to bring her back. He says, I'm not able to prove that she is married to someone else, as even he has dished her, the other person. And he says, now, can I make a will on plain paper without registering it further? I want to debar her from all assets, as she has left me and both my children, who are ailing, and they both have some blood disorder issues. So can he debar this person who's deserted?
See, in the case of self-acquired property, a man can do anything with the property. He doesn't have to give anything to wife also. Nothing. He can give the 100% of wealth through charity. See, people have this. That is what I'm saying. People don't know. This is the confusion. See, if the wife has run away, is not divorced, still he thinks that because she's not legally divorced, she has right. No, she doesn't have any right. A man who has earned this acquired property, he can give nothing to his children or his wife. He can 100% give to charity. So the wife cannot do anything. And even if the wife is divorced or not divorced, it doesn't mean anything. He can give everything to his child. He can give only to one son, only entire wealth to one daughter. Anything he can do with this wealth.
And the wife who's deserted has no rights, because it is a property he has bought of his own money.
So there's one difference. In the case, if he doesn't make a will,
Hanji.
then if the wife is not divorced, then she can claim equal right along with the children. Because then she's not divorced and she is class 1 heir.
Right.
Then she is legally wife, and then she will get equal amount as the son will get. So that is why very important to make a will in case of children like this. If it doesn't make a will, then wife can come and claim 1/4 of the whatever his size.
Correct. That's perfect. I think
there are 2 questions here. One is that Gurmeet Singh ji is again on the proceeds of insurance. There is a gray area on the proceeds of insurance policy to be willed, because he is not the owner and the owner is the nominee as per insurance rules. Could you throw some light? Sukhbir ji,
So what happens is that as far as the insurance company is concerned, they will give the money to the nominee only. Okay. Now, once the nominee has received it, but in the will, it is mentioned that this has to be distributed equally between 4 heirs. The person who is receiving the money, he is legally bound to share that with those 4 persons specified in the will. Insurance company does not come into your family jhamela. They are saying that this is the nominee, we'll give the money to the nominee. Baki aap log aapas mein jo karna hai kar lo.
Absolutely. So there's another question, continuation of the earlier one. It says, should the will be made separately for the joint property and joint accounts? I think there's no necessity of that.
It should be a single will.
Single will. Then he says there is a loan of 50 lakhs on a property in current scenario, how the will be made. I think that doesn't also make any difference.
That whoever is taking that property, that loan
liability will also be
that. I mean, you make, in respect of liabilities, make a very clear statement. Don't keep anything vague.
So there's one question. There is a property owned by a widow, 2 daughters and 1 son. All 3 are married. The children are all married. The son is having a daughter and son, requires NOC from daughters. So if the property is owned by the widow, I think she doesn't need to require any NOC. She can will it to anybody actually. Yeah. Right, Sukhbir? I think that's it.
Yeah, absolutely. Even if it is inherited from the husband.
Yes.
What is self-acquired? See, self-acquired does not mean that she had to
earn
money. Even if it is inherited, as long as it is not a HUF property. Yes. If it is a HUF property, then the different rules apply. But if I've inherited from my father, okay, it is my property.
Yeah.
I can deal with it. Okay. There's one question which has come here, that whether a probate is based on the location of the immovable property or the person should be living there. The answer is that the probate will be determined by the location of the property. If the property is in Mumbai, but let us say the person was living in Delhi, doesn't matter. Because the property is in Mumbai, probate will be necessary.
Perfect. Any more questions with you, Paramjeet Virji?
Yes, one, the same person I think is continuing. The father died in 95, the mother died in 2005. After death of husband, property was in custody and transferred to mother. Can a daughter ask her claim? There are 4 sons. 2005, mother died in 2005 and the father died in 95. No, I think...
Father has died intestate. I mean, it will come to the class 1 heirs.
Yes. That this 95 thing will, this 2005 thing come into picture only for the ancestral property, that the HUF property. Otherwise, the as per the Succession Act, if the father is died intestate, so in any 95 or 2005, daughter has equal claim because she's a class 1 heir. I think that's all with me.
Perfect. So our takeaways are, let us not believe in our own immortality. There comes the time when we need to plan for something unpleasant as death. Therefore, let us be smart. Let us sync all our assets and properties and have nominees and wills created according to the people we want to give it to. Sir, I think there is somebody who's raised her hand. So I think if you allow one more question,
yes,
if you don't mind.
Absolutely.
So I'm going to unmute. Parvinder, if you could do that, please.
Yeah.
Parvinder?
Yes, I have unmuted.
Hanji.
No, she's not unmuting herself.
Okay, so please mute person back again. So with that, we'll come to a close of today's session. But the point to take away is obviously to make a will. Otherwise, it creates a very uncertain and a very unsecure future. And obviously, if wills are not there, then relations will sour. And we would never want that to happen. I think we are now in the 2nd generation after the 1947 partition. And as Sikhs, as people who are entrepreneurs, who are the world's biggest and best jugaad people on earth. So I think now it is very important for us to also plan for succession to happen thereafter. With this, we would like to thank the Dadar Gurdwara Shri Guru Singh Sabha for their support in all the events that we hold. On behalf of EduSikh, we thank everybody who took part in the event. And of course, very importantly, our panelists for their very informed and judicious views, Sardar Paramjeet Singh ji and Sardar Sukhbir Singh ji. Thank you very much and have a very wonderful evening. If there are questions, please do pop them up into the email IDs mentioned earlier. Thank you very much. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh.